All right. Here we've jumped forward 2 years later, and we have General Electric Company versus Gilbert. Um, the Supreme Court in this case, and because I'm going to cover these cases in sort of a brief shot, so we're not going to do this case like we normally do. One, for time reasons, I want to get through all of the stuff, and also because the factual setup, the background, the issue, all those things aren't really as important in these areas, because what we want to focus on is what's at the bottom of the slide, which is the Pregnancy Discrimination Act of 1978. And this case helps get us there. So in this particular case, the Supreme Court held that a company which specifically provided that all non-occupational sicknesses except pregnancy could be considered a disability was not illegal. So what this meant was that all benefits could be provided for literally everything else except pregnancy. And the Supreme Court says that this simply isn't illegal. Because again, it's not pregnancy-based, or it's not gender-based discrimination. So this decision was monumentally controversial. While, as we sort of covered in the Q&A, without guidance from Congress, this is kind of where the Supreme Court jurisprudence was going to go. But the decision was exceedingly controversial because pregnancy is and was then and still is exceedingly expensive. And this was a way for companies and states to get out of having to cover this act. And so Congress reasons that we have an interest in people reproducing. Reproduction is a good thing for the United States. But in order to be able to reproduce, the cost of this pregnancy has to be something that families can bear. If individuals are going to not be able to afford a pregnancy because this sort of rampant pregnancy-based healthcare discrimination exists, then we should do something about it. So 2 years later, Congress, in response largely to Gilbert and also Goudeleg, passed the Pregnancy Discrimination Act of 1978, which does two primary things. It does one, it prohibits discrimination on the basis of pregnancy. The second is that it requires health insurance to cover pregnant workers. And you'll see this addendum to that second part, because that second part is ultimately declared unconstitutional by the court. So the first part remains. It's good law. The second part is declared unconstitutional. It's declared unconstitutional in a case that happens in 1983, Newport News versus EEOC, because men sued arguing that this was an extra benefit that women get that men don't get. And therefore it was gender-based discrimination because women were getting more than men. There is a lot to consider going on in this. There are any number of procedures that men undergo that women will never have to undergo. Most of those procedures are covered under health insurance, but women will never receive those benefits. The difference here is that government was requiring it. What it turns out is kind of the marketplace in this environment wins out. The marketplace. Because while it was declared unconstitutional, it proved so overwhelmingly popular that if you are covered under a form of insurance at this point, it's very difficult to get any form of insurance that doesn't cover pregnancy. And the marketplace chose to provide this because it was so overwhelmingly popular and in demand. But this particular case does lead to the Pregnancy Discrimination Act of 1978. And the first part of the Pregnancy Discriminate prohibits discrimination on the basis of pregnancy still remains good law into the next case that we're going to do, which attempts to challenge, in which a law is put up against what this sort of discrimination looks like. And so we'll cover the other part of the Pregnancy Discrimination Act in the next case.